Tender of payment under UCC. Section 3. 604. A forgotten defense. The Ohio State University. 1978. Tender of payment under UCC. Section 3604. A forgotten defense. Goldsmith, Jeffrey M. Ohio State Law Journal. Volume 39, No. 4, 1978, 833-854. http://hdl.handle.net/1811/65077 Downloaded from the Knowledge Bank, the Ohio State University's institutional repository. Knowledge Bank kbosu.edu. Ohio State Law Journal, Moritz College of Law, Ohio State Law Journal. Volume 39, Issue 4, 1978. Tender of payment under UCC. Section 3-604. A forgotten defense. A tender of payment may be defined as an unconditional offer by a debtor or obliger to pay another, in current coin of the realm, a sum not less in amount than that due on a specified debt or obligation. Tender of payment typically arises within the law of commercial paper when a party obligated on a negotiable instrument, at its maturity date, tenders the sum due to the holder. If tender is refused, and the holder subsequently brings suit to collect on the obligation, the party obligated may assert the prior tender as a defense to liability for interest, costs, and attorney's fees accruing on the instrument after the effective date of the tender. Article 3 of the Uniform Commercial Code has codified a tender of payment rule for commercial paper in Section 3-604. 1. Any party making tender of full payment to a holder when or after it is due is discharged to the extent of all subsequent liability for interest, costs and attorney's fees. 2. The holder's refusal of such tender wholly discharges any party who has a right of recourse against the party making the tender. 3. Where the maker or acceptor of an instrument payable otherwise than on demand is able and ready to pay at every place of payment specified in the instrument when it is due, it is equivalent to tender. Tender of payment under Section 3-604 has been litigated only infrequently since the enactment of the Code. Several reasons may be postulated for this lack of legal attention to tender. First, it may be that tender of payment infrequently arises in modern commercial transactions. As will be seen, tender only becomes an issue when the holder delays collection of the instrument after it matures and the party obligated on the instrument desires to stop the running of interest and costs on the obligation. It is possible that modern holders promptly collect their debts and hence tender of payment does not arise as an issue. In the early days of the common law when the doctrine of tender of payment arose, great distances and gaps in communication could easily cause delay in the collection of negotiable instruments. The modern commercial world does not operate under similar disabilities. Second, it is possible that parties obligated on negotiable instruments are unaware that tender of payment exists as a mechanism to stop interest and costs from running on an instrument after its maturity date. Tender. 1. Bocum v. Grade M. Inns. Co. of NY. 370 SW2D 863, 866 Tex. 1963. 2. UCC. Section 3-604. 3. The Uniform Commercial Code Reporting Service reports fewer than a dozen cases concerning Section 3-604. 4. See Notes 9-13 and accompanying text HFRA. Ohio State LAW Journal. Of payment in the negotiable instruments setting has been ignored in legal literature. Section 3-604 has not been the subject of commentary since the enactment of the Code. Third, because Section 3-604 of the Code fails to define tender, the definition must be derived from the common law. 6 Parties obligated on negotiable instruments may be unwilling to follow the rituals associated with tender at common law, out of ignorance or desire to avoid the bother of making a tender. The purpose of this comment is to explore the law of tender of payment in the negotiable instruments setting through an examination of tender under the common law, the negotiable instruments law, and Section 3-604 of the Code, and to explain the lack of use of Section 3-604. Exploration of the nature of tender of payment as it evolved from the common law to its present-day form will reveal that many problems relating to tender of payment remain unresolved by the Code. This comment will propose solutions to those problems. I. Tender of payment under pre-Code law. Tender of payment arises in a great variety of contractual settings. For example, a mortgager may tender a payment due on a mortgage to the bank. An insured may tender a premium due on a policy to an insurance agent, or a consumer may tender money due on an automobile to a loan company. 7 In order to clarify how tender of payment works for commercial paper, it is helpful to illustrate how and why tender of payment may arise in this context. A. The negotiable instruments setting. Two hypothetical negotiable instruments reveal typical contexts in which tender of payment may become an issue. In the first, A, in exchange for a $1,000 loan from B, states 5. J. White and R. Summers, Handbook of the Law under the Uniform Commercial Code Sections 13 to 18, at 443, 1972, makes only a passing reference to tender of payment under Section 3 to 604. For a general discussion of the law of tender, see comment. The Law of Tender in Texas, 29 Baylor L. Rev. 325, 1971. 6. UCC Section 1 to 103 reads, unless displaced by the particular provisions of this Act, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent. Estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause shall supplement its provisions. 7. For a discussion of tender in a variety of contractual settings, see comment, Supranote 5, at 325. 8. These are not the only commercial paper contexts in which tender of payment may be an issue. Similar considerations prevail when a party acts as an acceptor of an instrument, that is, agrees to honor the instrument as presented. See UCC, Section 3 to 410. This comment will not examine the problems associated with a tender of a check in satisfaction of a debt. See comment, Accord N. Satisfaction under the UCC, Section 1 to 207, 38011 OST. L.J. 921, 1977. Volume 39. 833. Tender of payment. I promise to pay be your order, the principal sum of SLOOO plus 10% interest compounded annually, principal and interest due and payable 1 year from the date of this instrument. The second instrument is a variation on the first and reads, I promise to pay be your order, the principal sum of $1,000 plus 10% interest compounded annually, principal and interest due and payable at the First National Bank of New York, 1 year from the date of this instrument. In both cases, A is the maker of the note, and B is the payee. As long as B retains a right of payment on the note, he is termed the holder. The difference between the two notes is that the second instrument is domiciled, that is, payable at a place specified in the instrument. Notes may be domiciled anywhere, but the most common domicile is a bank. The first note is payable on demand anywhere. In either case, B has the right to collect $1,000 plus 10% interest 1 year from the date of the note. The problem is that B, the holder, is not required to present the note for payment to A, the maker, on the date of the note's maturity. A's obligation to pay the principal and interest continues whether B collects on the date provided for in the note or 10 years later. Early English law established that makers of notes payable on demand had no right to presentment of the note for payment at its maturity. 9 This rule was in contrast to the law of checks, which required prompt presentment by the holder for payment. The English courts, however, did adopt the check rule for instruments domiciled at a bank. Since notes domiciled at a bank were analogous to an order on the bank to pay the note, the English courts took the view that presentment should be necessary. This distinction between domiciled and non-domiciled instruments did not survive in the United States. In the 1839 case of Wallace v. McConnell, the United States Supreme Court refused to require presentment for payment of domiciled paper. Hen the suit is against the maker of a promissory note, payable at a specified time and place. No demand is necessary to be averred, upon the principle that the money to be paid is a debt from the defendant, that is due generally and universally, and will continue due, though there be a neglect on the part of the creditor to attend at the time and place to receive or demand it. 12. 9. C. Roe v. Young, 2 Broad and Bing 165 CP. 1820 Stephan, Instruments, Payability, A Bank, 18 U. CML, RV 55, 60-65 1950. 10. Failure to present a check promptly for payment absolved the drawer from liability for any loss occasioned by the delay. C. Stephan, Supranote 9, at 58. 11. C. Sanderson v. Bose, 14 East 500 CP. 1811 Stephan, Supranote 9, at 61-62. The result is still good law in England. C3 Halsbury's Laws of England, Business and Banking, 58, 4th ed. 1973. 12. 38 U.S. 13 Pet. 136, 149 1839. C. Stephan, Supranote 9, at 65-68. 1978. Ohio State LAW Journal. The result was that makers had no presentment rights in the United States regardless of the type of promissory note. The resulting disadvantage for the maker is that, if the holder delays collection of the note after it is due, interest continues to accrue on the note in the sample notes, at the rate of 10% compounded annually. If the holder delays presentment for a substantial period of time, and if the note is for a substantial principal sum at a high rate of interest, the hardship placed on the maker may be very great. The maker's difficulties are further exacerbated when the original payee on the note is no longer the holder. If the note is negotiable, 3B may have sold or given the note to sin satisfaction of a debt. B, by endorsing the note over to C, relinquishes his right to payment of A's debt. It is now up to C to collect on A's obligation. Especially with notes payable only after a period of years, the note may have changed hands many times. Thus, the maker may not even know the identity of the holder, although domiciling the note assures the maker that the holder, whoever he may be, must collect at a place known to the maker. The hardships placed on the makers of negotiable instruments spurred creation of a mechanism by which makers could stop the accrual of interest on the note caused by the holder's delay in presentment. The law of tender was the answer. B. Formal requirements of a tender of payment at common law. A tender of payment is essentially an offer by the maker of the note to pay his obligation to the holder when it becomes due. Yet a tender of payment is really more than an offer. A tender, while having many of the characteristics of any offer, is, in the contemplation of the law, more than an offer to perform the obligation required of the obliger under the terms of his contract. In other words, tender is a broader concept than offer, the former including the latter. Every tender includes an offer, but every offer is not a tender. 4. What, then, makes a tender of payment more than an offer to pay the sum due on the note? The common law worked out various requirements that must accompany the offer before it becomes a bona fide tender. 1. The elements of the offer. At common law, an offer could be a tender only if it was unconditional and manifested the readiness, willingness, and ability of the maker to pay the holder the sum due on the instrument. 5. A tender of payment, in other. 13. Negotiability requires the existence of several formal elements set forth in UCC sections 3 to 104 to 114. 14. Comment. Supranote 5, at 326. 15. C. E.g., Bank of Lafayette v. Giles, 208 Gauss 674, 680, 69 SE 2D 78, 82 1952 Rotman v. Heavener, 54 Cal. App. 474, 202 p. 329 1921. Volume 39. 833. Tender ofpayment. Words had to be more than a hollow offer by the maker to extinguish his obligation. The unconditional nature of the tender could be destroyed by tendering the sum subject to a counterclaim against the holder. 6a maker could insist, however, that the holder perform a statutorily imposed duty without destroying the unconditional nature of the tender. Where it is the duty of the creditor, on tender of payment, to do a particular act, the offer to pay may be coupled with a demand upon the creditor to perform such act. E.g., in a case where, by statute, it is the duty of the creditor to give a release, on tender of payment a release may be demanded, for it is the performance of a duty imposed by law. 17. The unconditional offer by the maker had to be for the sum owing at the time of the tender. 18 older courts insisted that tenders are always to be considered strictujus. If a tender is not legal in every respect, even a court of equity will not support it, nor supply a defect. 9. Thus, if the maker failed to tender the exact sum due, the tender was defective. Modern courts, however, have relaxed this requirement somewhat to approve a tender of a reasonably approximate sum to the holder. 20. It was clear at common law that the maker had to tender payment to the party to whom the sum was owing. If the original holder of the note had sold it or transferred it to another person, and the maker knew that the original holder no longer had any interest in the note, the tender had to be to the new holder. 2 feet. In the absence of a right to prepayment, the maker could not tender payment before the note became due. 22. And if the tender occurred after the maturity date, the tender had to include interest on the note up to the date of tender. 2. Methods of tendering payment. Makers of non-domiciled notes faced considerable difficulties in making a tender if the holder could not be easily located. The Supreme Court of Texas in Bocum v. Great American Insurance County of New York stated, at common law where no place of payment is specified or fixed by law, the rule is that the tenderer must seek the tenderee and make a. 16. Margolis v. Whitman, 169 NYS. 573574 App. Div. 1918. Brooklyn Bank v. DeGraw, 23 Wend. 342 NY. 1840. 17. Balmev. Wamba, 16 Min. 106108 1870. Upon payment the maker today has a right under UCC Section 3 to 505 LA to a return of the note or a receipt of payment. 18. Comment. Supra Note 5, at 329. 19. King v. Finch, 60 Ind. 420, 422-23 1878. 20. In Capital City Motors, Inc. vs. Thomas W. Garland, Inc. 363 SW2D 575, Mo 1962, failure to tender 4 days interest on S1000 did not destroy the tender. In Duke v. Pugh, 218 NC. 580, 11 SE2D 868, 1940, a tender of 1.25 less than the amount owing did not destroy the tender. In Matzker v. Page, 62 Wash. 170, 113 P 254, 1911, failure to tender 3 days interest on S40 did not destroy the tender. 21. Kentucky-Virginia Stone Company v. Fortner, 159 VA 234, 165 SE. 401, 1932. 22. Ship v. Anderson, 173 SW. 598 Tex. Civ. App. 1915. 23. Duke v. Pugh. 218 NC. 580. 11 SE2D 868 1940. 1978. Ohio State Law Journal. Tender to him if he can be found by the exercise of due diligence. 24. The question then became one of assessing the due diligence of the maker. 1. Case did conclude, however, if the holder had left the state there was no duty on the part of the maker to follow the holder into another jurisdiction in order to tender payment. 25. The ease of making a tender of payment was increased with respect to domiciled instruments through the doctrine of constructive tender. The maker could effect a constructive tender by having an adequate sum on hand at the place of payment specified in the instrument. The United States Supreme Court in Wallace v. McConnell officially approved the doctrine of constructive tender when it wrote, hold the maker not find his note or bill at the bank, he can deposit his money to meet the note when presented, and should he be afterwards prosecuted, he would be exonerated from all costs and damages, upon proving such tender and deposit. 26. The doctrine of constructive tender evolved as a way of relieving the maker from continual presence at the place designated in the note. It was clear, however, that regardless of whether the note was domiciled, the maker did not have to tender when it was certain that the holder would reject it. This rule was based on the equitable principle that the law will not require the doing of a useless thing. 27. The state of Iowa has enacted legislation to aid makers of non-domiciled paper in tendering payment to an unknown or absent holder. The statute 28 allows the maker to leave funds on deposit with a court for the holder. By tendering the debt into court and giving notice, the maker can effect a valid tender when the holder is absent or unknown. This statute is unique in extending the possibility of a constructive tender to makers of non-domiciled instruments. Given the potential hardship to makers of non-domiciled paper when the holders are absent, this statute makes practical sense. 24. 370 SW2D 863, 867 Tex. 1963, 25. Stansberry v. Embry, 12810, 103, 109, 158 SW. 991, 993 1913. 26. 38 U.S. 13 Pet. 136, 150 1839. Accord. Forwood v. McNeese, 143 MD. 1. 121A. 855 1923 Rodman v. Heavener, 54 Cal. App. 474, 202 p. 329 1921 Hennessy v. Woodling, 199 SW. 564 Mo Court App. 1917, 27. C. E.G., Bank of Lafayette v. Giles, 208 Ga. 674, 679, 69 SE2D 78, 82 1952. 28. Iowa Code Ann. Section 538.5 Sup. 1978 provides, when an instrument for the payment of money is due and the holder is absent from the state or his identity or whereabouts are unknown and the instrument does not provide for a place of payment, the maker may tender payment at the last known residence or place of business of the last known holder, and if there be no person there authorized to receive payment and give proper credit therefor, the maker shall be deemed to have tendered payment and interest shall cease on the date of deposit if 1. The maker deposits the amount due with the clerk of the district court in the county where the maker resided at the time of the making of the instrument, if he was then a resident of the state of Iowa, or if the maker was a non-resident of the state of Iowa at the time of making, with the clerk of the district court. And 2. B. The maker within 3 days gives notice of such deposit by ordinary mail to the holder, if his identity and address are known. Volume 39. 833. Tender of payment. 3. Keeping the tender good. Regardless of the effectiveness of the maker's original tender of payment, an additional requirement generally existed at common law that the maker had to keep his tender good, or open. In Fitzgerald v. Vaughn, the Georgia Supreme Court wrote, a tender, to prevent the running of interest, must be continuing. The fact that a tender is made and refused is not sufficient to stop the running of interest. It must also appear that the tender has been kept good by the tenderer being at all times ready, willing, and able to pay the amount tendered. 29. The rationale for requiring the maker to keep his tender good was that after the date of the note's maturity the money legally belonged to the holder. Since the maker's obligation did not cease until the note was collected, the maker had to demonstrate the seriousness of his offer to pay by keeping the tender good. Two exceptions to the necessity of keeping a tender good arose at common law. In a court of equity, it generally was not a fixed requirement that the tender be kept good, 3 degrees unless the maker sought affirmative relief from the note. 31 The rationale stemmed from the equitable principle that a party coming into equity for affirmative relief must himself do equity. 32. The second exception to the necessity of keeping a tender good was that the discharge of a surety was not dependent on the continuing tender of the maker. The Supreme Court of Indiana in Spurgeon v. Smith stated, "A creditor impliedly undertakes that the debt may be paid at maturity, and if he refuses to accept the money due, when tendered him, he breaks this implied undertaking, and loses his claim upon the sureties, for the act is injurious to them." 33. How could the maker keep his tender good? By far the most common procedure was to allow the maker to deposit the money due on the note in court. 34 Many jurisdictions imposed such a profert in curia as an additional requirement for an effective tender. The Colorado Supreme Court, in Westcott v. Patton, stated, "In order, however, to render this plea of tender effective, when permissible, it would be necessary that it be accompanied by the tender and actual payment into court, subject to the plaintiff's disposal, of the money admitted to be due." 35 The equity courts. 29. 189 GA 707, 710, 7 SE 2D 78, 80-81 1940. 30. Ano. 12 ALR. 938 1921 Thompson v. Cranes, 294 I 11.270, 281, 128 NE. 508, 512 1920. 31. Ano. 12 ALR. 938, 945 1921 Jefferson Title and Mortgage Corp. v. Dempsey, 266 NY. 190, 194 NE. 403 1935. 32. Tuthill v. Morris, 81 NY. 94, 100 1880. 33. 114 ND 453, 455, 17 NE. 105, 106 1887. 34. Wallace v. McConnell, 38 U.S. 13 Pet. 136, 140 1839 Bank of Lafayette v. Giles, 208 GA. 674, 69 SE 2D 78 1952 Balmay v. Wamba, 16 Min. 106 1870 NY. CZ v. Prac. Law Section 3219 McKinney 1970. See Note, Tender, Payment of Into Court, 7 Mark. L. Ray. 233 1923. 35. 10 Colo App. 544, 547, 51 p. 1021, 1022 1898. 1978, Ohio State Law Journal. Did not impose the requirement that the money actually be brought into court. 36. Not all jurisdictions imposed upon the maker the duty of bringing the sum into court. 37 Tender could be kept good simply by keeping the money perpetually available for the holder, for example, by depositing the money in a bank account for the holder. Montana and North Dakota enacted virtually identical statutes expressly providing for this procedure. An obligation for the payment of money is extinguished by a due offer of payment, if the amount is immediately deposited in the name of the creditor, with some bank of deposit within this state, of good repute, and notice thereof is given to the creditor. 38. Irrespective of the method of keeping the tender good, the maker had to keep the funds in readiness to pay the holder. The maker could substitute other funds for those originally deposited. 39 As long as the amount on deposit did not drop below the amount owing to the holder. 402 Advantages attended a deposit in bank over a deposit in court. First, a deposit in court was generally held to be an admission by the maker that the sum tendered was actually owing to the holder. 4 feet If the maker had an assertable defense against the holder, a deposit in court would be unwise. Second, If the maker wished to substitute money or its equivalent for the sum originally tendered,